compare for me, because you just mentioned the sonogram law, and I want to talk about SB5 as compared to the sonogram law. Were there changes made in the sonogram law in an effort to try to less limit access that aren't being made in SB5?
That's right. In fact, SB5 almost contradicts the changes that were put in place in the sonogram law.
Make sure I understand the changes that were made in the sonogram bill so that I'll understand what you say about what doesn't happen in SB5 so that it contradicts.
In the sonogram bill, what you may remember is Senator Rusty, in order to secure his support on that bill, he was very insistent that women in the rural communities that he serves and that other members of this legislature serve not have the burden of the 24-hour waiting period where the clinic were a far enough distance away from the woman's home that it would create a hardship on her to have to travel back to that clinic 2 days in a row.
So the argument would be that in order to not substantially limit access to the means effectuating that woman's decision, there needed to be a change.
Correct.
Right. I'm sorry, I interrupted you.
And, you know, obviously that was made to secure Senator Rusty's comfort with the bill in which he got there. I also believe, though, that making that change made it legally less subject to challenge under the statutes that are in place today, the laws that are in the constitutional interpretive laws that are in place today. What happens in SB5 that's different than that is that in SB5, the ambulatory surgical centers that exist in Texas today are in San Antonio, they're in Dallas, Austin, and Houston. And when you think about women needing to access those services or desiring to access those services, living, once again, in some of the rural areas that Senator Rusty represents, or perhaps that Senator Zaffarini represents, or that Senator Hinojosa represents, or Senator Lucio represents, we know that if those become the only available abortion service centers in the state of Texas, women will have to travel, in some instances, hundreds of miles in order to access abortion care services. And that might be subject to, and I believe it would be subject to, a challenge under the existing constitutional law as it relates to abortion.
And you've indicated that there ought to be a compelling state interest. On that distance, I want to make sure I understand your position. On the distance issue that we're talking about here, have you been satisfied that there is a compelling state interest to require clinics that currently can perform the termination of a pregnancy to go to an ambulatory, to go to the standard of an ambulatory surgical center? On the flip side of the coin, I guess, of limiting that access?
I do not believe that there has been any testimony, any empirical information that has been provided on the Senate floor, on the House floor, in the Senate hearings, both during the regular and the special session, in the House hearings, both during the regular and the special session, that demonstrated some compelling state interest in this new provision that's being asked to pass into law in the state of Texas.
Now, I've asked you about these cases that serve as kind of the underpinnings for laws related to abortion and the constitutional right that a woman has to make these decisions. I want to ask you about in SB5 another provision that I've heard you argue would limit access, and that is the 20-week provision. Are you familiar with any challenges that have been made in the United States to states that have created a 20-week provision like is in SB5, where they've been challenged on the basis that they violate a woman's right to choose as protected by the United States Constitution?
Yes, I am. And I think there have been 4 different states that have attempted or have passed similar laws.
And I want to be clear so that nobody has any question about, or we're talking about the provision in SB5.
That's correct.
Okay, I'm sorry.
And that provision in SB5 is the same provision that's been passed into law in, I think, 4 other states and has been the subject of litigation. Thus far, I don't think any court has found that that particular prohibition satisfies the constitutional requirements that have heretofore been set by the Supreme Court. And the reason that is prominently stated or most often stated for that is this issue of whether there truly is any scientific evidence that demonstrates fetal pain at that particular point in gestation. And that absent that compelling state interest, which might be found to be a legitimate one, because there hasn't been any scientific support to demonstrate that that has occurred constitutionally, laws in other states that have attempted to do that have heretofore not been upheld.
Something you had said earlier in either answer to my question or somebody else's question with regard to SB5 and this 20-week provision. I want to make sure I understood. Help me understand, and I've read some things from ACOG, the American Congress of Obstetricians and Gynecologists, and other places, the difference between 20 weeks post-fertilization and 20 weeks gestation. Help walk me through that, and that as it applies to SB5.
The concern that was raised, and I read a letter about it, I believe it was from TMA, it may have been from ACOG a little while ago, talked about the fact that the standard in determining the age of a fetus, or the developmental age of a fetus, has always been based on prior menstrual cycle. And that is so because it's very difficult to determine the actual point of conception. For different women, it's different. We ovulate at different times. But that seems to provide the most sound basis for making that determination. Under the provisions in SB5...
I'm sorry, if I might interrupt. The basis that is generally used as a sound basis for determining gestational time is last menstrual period.
Correct.
All right. I'm sorry.
LMP, as it's referred to by doctors. And what's different about SB5 is it asks instead for fertilization, the time of fertilization, to become the operative time in which gestational age is measured. Now, what the medical professionals say, and the testimony they provided during committee, and some of which I've read today, is that absent in vitro fertilization, there really is no medically reliable way to determine what that date is. And in fact, by using that date, it actually probably is overestimating fetal age, perhaps even significantly, so that a 20-week fetal age based on that point of reference,
fertilization,
exactly, may be inaccurate and may be actually a gestational age that's only 18 weeks, for example.
Okay. Is that one of the reasons, is it your understanding that that's one of the reasons that ACOG, which is the American Congress of Obstetricians and Gynecologists, I think I've got that right, maybe American College, but ACOG has established that it's opposed to Senate Bill 5?
That's correct. That is one of their bases for opposition among many.
Have you heard anything, either on the floor or in the hearings, that causes you to think that utilization, like SB5 does, of the 20 weeks post-fertilization is a more appropriate standard than what the American Congress of Obstetricians and Gynecologists are indicating ought to be any standard you use for determining gestational age, which is LMP.
I've not heard anything that leads me to believe that that is an incorrect, that the LMP is an incorrect way, and that that is a better way of determining gestational age.
Is there, in your mind, do you have any understanding as to why in Senate Bill 5 there's an effort to utilize fertilization, 20 weeks post-fertilization, as opposed to utilizing LMP?
Well, according to ACOG, their belief is that it is done in order to actually constrain even further the limit upon which a woman could receive an abortion service, actually driving the gestational age not even to 20 weeks, but even lower than 20 weeks, because they believe it would create a lower gestational age and likely would be prohibiting women from having an abortion even as early as 18 weeks of pregnancy, rather than the current protection that exists under Roe v. Wade and Doe versus Bolton.
You mentioned earlier today, I think, that Senate Bill 5 is also opposed by the Texas Medical Association.
Correct.
And what is your understanding as to the reason the Texas Medical Association is opposing the passage of Senate Bill 5?
The letter that they provided dealt in most part with the licensing of physicians that would be required under Senate Bill 5, and that this requirement that a physician be licensed within a facility, a hospital, within 30 miles of the abortion facility is constraining the practice of medicine in a way that has not had a compelling interest demonstrated to prove why that's the case. They also have objected to the bill because of the piece of it that was originally Senator Patrick's bill in terms of how the abortion-inducing drug is to be administered. And they believe that it is a tremendous stepping into the doctor-patient relationship in a way that the legislature really has no business intruding upon, and can't demonstrate that they've intruded upon the patient-doctor relationship in other instances, and why somehow in this particular arena they would have this intrusion.
My memory is that in the debate on the Senate floor with regard to SB5, that, and I want to go to one of the reasons you indicated you believe TMA has indicated its opposition to Senate Bill 5, and one of those was the requirement of having admitting privileges a certain distance away, 30 miles away. My memory was that in that debate, an amendment was offered that amendment said instead of the doctor needing to have privileges 30 miles away, we would codify an administrative code provision that would allow for that doctor to have a relationship with someone, another doctor, that had admitting privileges at a local hospital. Do you recall that?
I do recall that.
Now, from the standpoint of, and I know you're not going to be able to speak for TMA on this, but if one of the objections of the leading physician organization in the state is that you've created an undue restriction on access because physicians may not be able to have admitting privileges at a local hospital 30 miles away, one of the ways to solve for that would at least be to utilize something that's already in the administrative code. It's a rule that applies, and codify that, where you would say we will be able to deal with emergencies under Senate Bill 5 by allowing that doctor to have a relationship with somebody at a local hospital. Is that correct?
That's correct.
So that would have at least been something that, if we're just talking about providing protection for women and assuring that an appropriate standard of care is met, that would have been one way to assure that safety without unduly restricting a woman's access to making that decision.
That was the argument made at the introduction of that amendment, and I agree with the rationale behind that argument.
Another amendment that was offered, and let me ask you this question. In Senate Bill 5, which I think we would all agree, I don't think I'm going to get a point of order on asking this. Senate Bill 5 deals with abortions.
That's right. In fact, I believe the subject line in the legislative listservice, where we typically look at our bills, the subject line on this bill says abortion.
And we've heard time and again that the reason to be for SB 5 is that we want to have safety for women, but we've also heard that it's to reduce the number of abortions. Have you heard that?
I'm sorry, can you repeat?
Sure, be happy to. One of the reasons we've heard that people support Senate Bill 5 is because they want it to reduce the number of abortions.
That's right. Some people have indicated that.
And frankly, we would all like to reduce the number of abortions.
Yes, we would.
Is there anything in Senate Bill 5 that will help us reduce the number of unwanted pregnancies that could result in abortions?
In fact, I do not believe there is, and as you know, Senator Watson, those were a pertinent part of our debate on Senate Bill 5, that we believed that while it, in the name of making better health services for women available, actually will decrease abortion services to women. We made arguments to decrease the need for abortion. We believed that the best way to decrease the need for abortion services was not through creating constitutional intrusion on women's rights to access those services, but instead to reduce the number of women who would be in demand for those services because of certain things that we could do at the state level to assist with that.
So, for example, my memory is that amendments were offered on the floor to SB 5 that would have provided parents with notification about what their children were learning with regard to sex education in the schools.
That's correct. I believe you had 2 amendments that you offered in that regard, Senator.
And neither one of those amendments were taken on SB 5, so SB 5 doesn't have any provision in it that would help us reduce the number of unwanted pregnancies in the state.
That's correct.
And what's your understanding about where the state of Texas ranks in terms of the number of teen pregnancies?
I believe it's number 2. I believe that's right. I know it's in the top 3, but I believe it's number 2 in the country.
How about on second teen pregnancy?
And I believe it's possibly even number 1 on second teen pregnancies, perhaps number 2 now, but somewhere right there in the top 5, no question about it.
I want to go back to the idea that one of the reasons some have said, and I think, by the way, some of the members on the floor legitimately want to increase safety. I think all of us want to increase safety in any realm of health care that someone might be receiving.
No question.
But the argument has been made that on SB 5, the reason we should be supportive of it is because it would provide greater public health. Is that correct?
That's the argument that was made by Senator Hager, yes.
And I'm looking at the ACOG letter, the letter that you referred to, which is the letter of the American Congress of Obstetricians and Gynecologists, District 11 from Texas.
Yes.
And I'm looking at page 2.
Yes.
And down there at the bottom of the page, correct me if I'm wrong, but one thing that it says, the committee substitute Senate Bill 5 requires additional standards that are unnecessary and unsupported by scientific evidence. And then it indicates in that first bullet point, Committee Substitute Senate Bill 5 does not promote the public health objective it claims to enhance. In fact, it harms public health by restricting access to safe, legal, and accessible abortion services. Now, I don't want to talk about the constitutional aspect of substantially limiting access to the means of effectuating the decision to have an abortion that is protected by our United States Constitution. But let me ask you, what is ACOG talking about when it says it won't actually enhance safety, instead it will do the opposite?
Well, basically what it's saying is that it will do the opposite because women now will have limited access versus what they currently have in Texas today, and that limited access actually will undermine women's health. It's not in this particular letter, Senator. I think ACOG wrote about 4 letters to us. It actually was not in the binder that I had either, but I had it on the floor when we debated Senate Bill 5. And ACOG specifically, in the closing part of that letter, talks about the fact that they believe this will do harm to women's health in Texas. And they essentially cite to that period of time where women sought abortions in less safe conditions, and that they fear that with the limitation on where women can go to access these services, women, particularly poor women in rural communities, will once again be driven to an unsafe environment where they seek abortion services. Interesting, Senator, statistic, and I know in one of these binders I have somewhere, there's an article about the fact that when you compare different countries and their abortion laws, the demand for abortion and the incidence of abortion does not go down, even where the laws try to tightly confine it or prohibit it altogether. And when ACOG talks about that as it relates to Senate Bill 5, I think they understand all too well, much better than you or I, because this is the work that they do. They understand all too well that by changing the law in Texas and limiting women's access to where they will get safe legal abortion is not going to decrease the demand for abortion, but instead is going to push women into less safe circumstances where they'll seek it.
It makes you worry, or let me ask you, since I'm asking questions, does it make you worry that Senate Bill 5 won't limit abortions, it may just limit the legal ones?
And even further, I would say, it just may limit the safe ones.
Let me ask you about safety and unintended consequences of Senate Bill 5. Did ACOG make any reference to unintended consequences that would make the treatment of certain conditions like ectopic pregnancies more expensive? Maybe you ought to,
yes.
Could you explain that aspect of one of your concerns about Senate Bill 5?
Specifically, what ACOG said relative to the committee substitute for Senate Bill 5 was that it would have unintended consequences by making the treatment of certain conditions more difficult and expensive. It said that ectopic pregnancies are frequently treated in outpatient facilities and physician office settings, and that SB5 would prevent doctors from treating those cases as they normally would. I actually will share something very personal with you. I have experienced an ectopic pregnancy where I was able to be treated by my doctor in his office, and it's a very timely procedure because...
Can you explain what it is?
Yes, an ectopic pregnancy is when the embryo begins to develop outside the uterus, typically in the fallopian tube. And if that is not immediately dealt with, it can endanger the life of a woman if there is a rupture of the tube. Fortunately, many women right now can go to their doctor and immediately upon the discovery of that, rather than having to wait to be admitted to a hospital or an ambulatory surgical center, women can be treated for that ectopic pregnancy in that doctor's office.
Right there in the office.
right there and right then, and the right then is the important part.
What does Senate Bill 5 do that changes that?
What Senate Bill 5 would do would be to require, according to ACOG, that those could no longer be provided in outpatient facilities, but instead that they would also have to be provided under ambulatory surgical center settings in order for the doctor who's providing that ectopic termination to be legal.
Thank you, Senator Davis. Thank you, Mr. President.
Thank you.